Thank you to our panelists for saying hi and for joining us. Um, as you have seen, we have four panelists. All of these have a wealth of knowledge in what we are going to be discussing today. We all acknowledge of their expertise, their knowledge, and their experience in their various fields, and we are so grateful for their participation.
Thank you, Temo, for the introductions and for laying the groundwork. Just as a matter of background, the 1989 Refugee Act is the act that has been used for the past 30 years. And its review is of necessity at the moment because of different reasons that we're going to hear from the panelists here. So my first question to Divine, who has lived as a refugee in Malawi, is just for her to briefly share her story and how the current Refugee Act has affected her as a refugee.
Thank you so much, Brenda. And well, quick brief story about myself. My parents are originally from Burundi, but I was born in a refugee camp in Tanzania before my parents decided to move to Malawi refugee camp because Tanzania was no longer safe. So first we were in Luwani refugee camp in Mwanza, and when I was 4 years, that's when we moved to Luwani. But then that's when I began my primary education. However, when the government closed Luwani refugee camp, we were moved to Dzaleka refugee camp. And by then I was just 8 years old. And when we got to the refugee camp in Dzaleka, I continued both my primary and secondary school education. And later on, I was able to earn a diploma in social work through an online studies with Regis University. It's located in the US, but they also offer the online education to refugees in the camp. And then after spending almost about 15 years in Malawi, I was able to meet, I would say, an angel or destiny helper, an American lady who was in Malawi for some humanitarian work, and that was able to help me get into a school in the US where I'm currently pursuing my education, my bachelor's in international studies and global affairs. So I would say that the current refugee laws have impacted me in many ways. First of all, I would say that although Malawi was the only home, I would say, that I knew since I was very young, I was never fully accepted. Despite scoring like good points in my Malawi School Certificate of Education exam, I was not eligible for public universities due to restrict refugees policies. And the second one was that refugees are expected to volunteer without any payment. So even though they provide valuable services to organizations that are operating in Dzaleka. And the third, I would say that there are strict limitations on movement that forces refugees to remain confined to the camp, which creates a constant sense of restrictions and feeling unwanted. Thank you.
Well, thank you, Divine, for sharing your story. It's really touching to see that, like you've said, you scored good grades, but were not able to go into the public universities. I understand that there's so many others in that situation as well. I think the other questions we'll ask as we go as a follow-up question. But maybe to Shakira, what are the key areas of the current Refugee Act that you think that they need revision or updating, having heard from Divine the restrictions that she has experienced as a refugee? Maybe can you share a little bit about that?
The areas that I think require revision is I'd say almost everything, because when you look at the current Refugee Act, it doesn't necessarily solve the current problems that we have in the refugee space. And I would actually like to start with what Divine has just stated, that she was able to attain very good grades, but unable to enroll in a public university. So one of the things that I'd like to see revised in the Refugee Act would be the encampment policy, which basically restrict refugees with regards to like education, employment. There has to be something specific, provisions that showcase how we're going to solve this, because an act or a law is there to solve some sort of a problem. So now that we know these are the challenges that we have at the moment, the revision ought to reflect these problems that we have on the ground. And in addition to that, we would like to see clear provisions that stipulate rights and freedoms of refugees, obligations of refugees and asylum seekers. Would also want to see that it has incorporated the principles of non-refoulement, because this is, I think, one of the challenges that we've been facing after the 2023 relocation. There's been a lot of instances where people have been sent back to countries where they come from, places that they still have political unrest, places like DRC, where they still it still poses a threat to the people that are being sent back. So the new act, or rather the revision, has to clearly incorporate the principles of non-refoulement and also protection of refugees and asylum seekers from persecution rather. Another thing that I would like to see would be we're supposed to have durable solutions, right? As it is at the moment, we have even after the 2023 relocation, we have refugees that are now back in their communities. So now the Act has to show how are we going to address this. We need to have proper regulations, proper procedures. If people are to be integrated with the local communities, what are the procedures? How do we go about it? Who amongst the refugees can be integrated rather in the local community? So these are things that needs to come out clear in the revisions. And most importantly, the protection of the protection from persecution. We have so much of those ongoing. I mean, I'm not new to Inua, and I know there's been a lot of problems that we've had post-2023 relocations. So to address these problems, I think these things need to come really clearly on the revision that it is at the moment underway. Thank you.
Thank you so much, Shakira, for your insightful answers. I hope we are all able to follow. Mr. Robert Kandula, I hope you are able to hear me.
Certainly.
Thank you so much. As we have introduced you as an officer of the Law Commission, I wanted to know, and I think my colleagues would also like to know, and everyone else online, that what really prompted the review of the current Refugee Act.
Thank you very much, Temanani, for that question. Let me point out first the origins of the 1989 Refugees Act. It was, I would say, in response to a sudden influx of refugee situation. Malawi has always hosted refugees from way back. Maybe at the time they were not being recognized as refugees, strictly so-called, because most of them would come from across the borders from our neighboring countries like Zambia or Mozambique. It could be because of things like famine, because historically, I would say the people around the border areas of these countries are related. And in fact, we have it on record that the then former head of state, Dr. Hastings Kamuzubanda, recognized the relations that are there between Malawi and the people in some of the neighboring countries. So with that background, whenever there were problems across borders, people would always move to the other side and they would be received in the communities, and he provided the necessary assistance. When things were better on the other side, they would always go back. And that went on without maybe being significantly noticed, because it was just like a normal occurrence along the border areas. If maybe for some reason the numbers were high so that the local community could not provide the assistance, then government officials could come in. Usually it would be police officers in liaison with the district commissioner's office, and maybe some aid agencies like the Red Cross would come in to provide that additional assistance. But otherwise, everything was normal until around the late 1980s, when we now had a sudden influx of refugees, mostly during the time we had the civil war in Mozambique. So at that time, it became now, I would say, difficult for local communities to contain the large numbers of people who were coming in. So that is where now government took measures or steps at the central level to address the situation. So in this regard, one of the avenues was now to approach the United Nations High Commissioner for Refugees, Malawi being a member state of the United Nations. At the time, Malawi had not yet ratified the 1951 United Nations Convention relating to the status of refugees and its 1967 protocol. So Malawi ratified that convention in 1989, and also went on to accede to another convention, the Organization of African Unity Convention, relating to specific refugee problems in Africa. Now, the requirements under the legal system of Malawi is that when such instruments have been ratified, they also need to be domesticated. By domesticating, we mean to give them recognition in the domestic or municipal laws so that they become part of the law. So that's where now the 1989 Refugees Act came in. Because maybe it was enacted with an eye to a specific or particular problem, there were maybe many other areas that it did not address, which nevertheless are to be found in the conventions that it was domesticating. Now the question would be, why couldn't those things just become directly applicable since Malawi had ratified the conventions? With particular regard to the 1951 convention, the UN convention, which I'll be referring to as such, Malawi entered some reservations, certain articles of that convention. At the time, it was acceding to that convention. So by virtue of the reservations, it means it reserved some kind of, I would say, discretion as to whether to put into effect the aspects as put forward in the convention, or maybe to put certain things on hold. So there were quite a number of those reservations. And then from the 1989 situation, going into the early 1990s and moving on, the refugee situation now changed, not only to relate to people from neighboring countries like Tanzania, Zambia, or Mozambique, but also to touch on people from as far away as Rwanda, Burundi, and the Democratic Republic of Congo. So we now had a kind of unique situation in terms of management and protection of refugees. Because of that, in early 2007 to be specific, the then agency which was responsible for the protection and management of refugees, that was the Department of Poverty and Disaster Management Affairs, which was in the office of the President and Cabinet. wrote a submission to the Law Commission for review of the Act. Of course, while the Commission was looking at that submission, it also received another submission, this time from the Department for Refugees, which had taken over. And this was now as recent as around 2019, 2020. So you may see that it hasn't been like a one-off situation, requirement for the review of the Refugees Act. It is something that has been recognized over time. Specifically, going by the submissions that the Law Commission received, it was to do with certain specifics relating to the management, management and protection of refugees, because the way the act was framed, it kind of just provided for the administrative framework in terms of refugee status determination, cessation, and other matters as basically provided under the conventions. But now, like the specifics in terms of the institutional framework and the other aspects to do with the management of refugees, the rights, as others have pointed out, were not clearly spelled out. I would say, from what is on record, those are the factors that necessitated the review of the Refugees Act and the submissions that the Law Commission received. Thank you.
Thank you, Mr. Kanduru. That was really insightful. I'm sure most of us were not aware where we began with the story of the Refugee Act, or where we are really coming from about stories of refugees. Mr. Victor, I hope you can hear me. I have a question for you.
Yes, I can hear you, Tema.
Thank you so much. I wanted to know from you, are there any positive aspects in the current Refugee Act that you see?
Yeah, I think on the positive, I would say that I think there was principle of non-return of refugees to the countries where they are coming from. Though recently we have seen that I think that again is not being applied. So just to sum up is that the way Mr. Kandura has mentioned, I think as a country we are not prepared to have to host refugees. That's why you find that the act itself it was not human rights friendly, and it's just our hope that maybe in the coming one, maybe we might include some provisions. So to say, I think the one thing that I can just identify is that one. You can proceed asking me a follow-up question. Maybe I answered very quickly before you finish your questions.
All right, thank you. From what you have said, it seems the positives aren't as many as we had all hoped for.
Sure.
Yeah, and from what I'm seeing, there are more negatives than positives. But I just wanted to know, how have these negative aspects affected refugee protection? And maybe you can also expound to talk about maybe the type of work that you do and how they have affected how you're doing your work in terms of protecting the vulnerable and the minority groups.
Yes, I think I've noted recently that I used to respect my country in terms of access to justice to all people, regardless of the status. But I've seen that this act is lacking due process of the law. We had some cases whereby a refugee maybe is complaining and is seeking legal remedies. Shakira can attest to that. You find that I think the time you are pushing for the cases, that's when the time the immigration department will come in and make sure that they should rush also their process of deporting that refugee, which means that they were not even giving an opportunity to a refugee to be heard in the court of law, which is against the spirit of our constitution, because our constitution says that each and every person can access justice through our courts. So that's the problem that they have noted, and we have been fighting for that. We have been in court just to assist some of them, but I think in terms of successes, you find that I think we had minimal. At a certain period, actually thought that maybe it's the position of judiciary that they have decided not to entertain the cases from the refugees. And what also bothered us more was that we cannot go to any other court. It was just one particular judge who was handling all the cases. And then we said that I think this is something weird, but we lived with that until now. And I think the other thing that I can also mention is like the delays in the processing the asylum seekers, when assessment of asylum seekers. You find that I think it was taking ages, years without processing them. But most of them, at the end of the day, we find that they are being sent back to their original homes, which was to us was abuse of human rights. Again, we have also tried to be in court to assist them, but we have seen that our courts, they were not responsive to the issues of refugees. In other words, we are saying that access to justice for them, it was like zero. So that's what I can say regarding the negatives that we identified in the act. But again, also we found that I think the Refugee Act and also the Immigration Act, they were not speaking to each other. You find that I think the immigration is doing the other thing, the Refugees Act is saying another thing. So it was also putting the people who were the refugees in dilemma, and most of the time it was like the Immigration Act, which was actually managing to chase things. That's why you find that a lot of people that have been taken back to their home countries, because these two acts, they were not speaking to each other. So that's why I'm saying that I think maybe it's now making sense that I think we rushed because we had a situation. But probably maybe now that I think we have seen it all, maybe it's the time that we are going to have an act which is going to be human rights friendly, and it's also going to accommodate the issues and the access that was lacking in this one. Thank you.
All right. Thank you, Mr. Mhango, once again. You've given us a few insights on the matter of human rights to the refugees in relation to the current act. From what you have said, there's a lot that we are doing wrong to the refugees because they don't have the rights as are enjoyed by the rest of us in the country. You have mentioned the lack of access to justice, which is one of the biggest challenges that they face. So, like, basically, I like what you said, that maybe as a country we're not prepared to host refugees, and maybe we need to do better in that area. So, with that said, maybe another question to Mr. Kandulu. The act is it's like now you're under review, and there are consultations taking place. Can you give us an outline of the process that is taken by when revising the act? Like, who is involved? What are the expected timelines for completion? I know that it's been a while since we started this review. We've talked about it for years, but this is now 2025, and we're still nowhere closer to finalizing it. So please take us through the process of revising the act. How does it really go?
Basically, the process of law revision is provided for under the Constitution of the Republic of Malawi, 1994, as well as the Law Commission Act, Chapter 309 of the laws of Malawi. I would say the key aspect that is emphasized there is that of consultation whenever conducting law reform or law review process. So what normally happens is that first, the commission receives a submission or a request to have a certain law reviewed or developed. If there is no law at all in an area, but there's need to have a law in that area, then a person, it can be a government entity, the Attorney General, it can even be a private person, can approach the Law Commission indicating the need for that law review or law reform. So we call that a submission. When the commission receives the submission, it looks at it, and then once it's satisfied that indeed there is that gap that needs to be addressed, it takes it as one of its program areas. And then a team of experts is assembled. So this assembly of team of experts is provided for under the Constitution, that whenever the Law Commission is conducting a law reform process, it has to do so with the assistance or involvement of experts in the area of law under review. So that team of experts, we call them special law commissioners or members of a special law commission. Basically, these people are the ones who now look at the various issues that are brought to their attention by program officers. Program officers are basically law reform officers or legal officers employed by the Law Commission, assist with legal research and the other matters that attend to the law review process. So the program officers normally develop what we call the issues papers, which highlight the current status of the law, the gap that is there, and also highlight what could be the options. From the issues paper, the program officers would further go on to try to look at the other jurisdictions and even come up with the possible alternatives for proposed legislation in what we call a discussion paper. So those two documents, the issues paper and the discussion paper, guide the members of the Special Law Commission when doing the law review process. Of course, the members of the Special Law Commission are not restricted to the issues as presented in the issues paper and the discussion paper. Since they are experts in the area under consideration, they are at liberty to come up with further issues or even to discard the issues that have been raised by the program officers and develop their own issues based on their expertise of that area of law review. Now, when the Special Law Commission is empaneled, the members are not like public officers or employees in the public service. No, they are simply there as the experts. That's why we call them Special Law Commissioners. What it means is they are employed elsewhere if they are in employment, or they could be carrying out their own business elsewhere as private citizens or individuals. So they only come to the Law Commission to attend to the business of law review at any particular time. It could be conducting discussions in plenary or face-to-face meetings. They can also do it virtually, as we are doing right now, or consulting with the public or key stakeholders as required by the Constitution and the Law Commission Act. Whenever the Special Law Commissioners are meeting or are carrying out their business, they are assisted by the program officers. So once the commission starts or has met in its first meeting, normally they would adopt terms of reference, which highlight the key areas of the law review process that are to be addressed. They would also adopt a work plan. A standard work plan, all things being equal, is supposed to have a program that would run for around 18 months, and then it is concluded. I'm saying all things being equal because the other issues that come in are the resource constraints, money for the Special Law Commissioners to conduct their business. It could be carrying out consultations or even carrying out their meetings in plenary. So there have been instances where the Special Law Commission is ready to continue with the business, but maybe there are challenges regarding resources. And so for 2 or 3 months, the Special Law Commission does not meet. That may reflect on the work plan. But otherwise, a standard work plan or for a law reform process could be up to 18 months, and then everything is concluded and done. So after adopting the work plan and the terms of reference and the issues paper and the discussion paper, that's when now the commission starts its deliberations, first of all, among the commissioners themselves, to come up with what we call tentative findings. So those tentative findings are then taken to consultations with key stakeholders as well as the general public. The general public is met through what we call the consultative workshops. It can be regional consultative workshops where the commission moves to the various regions of Malawi, the north, the south, or the eastern region, as well as the central region. Then we can also have what we call key stakeholder consultations, where the commission identifies, I would say, institutions or people who are key to the issues that are being considered under the law reform process. So those would also be engaged in what we call one-on-one consultations. And then after the, or rather during those consultations, the commission presents its tentative findings. The tentative findings are basically the gaps that it has identified, and for the key stakeholders to present their views on those gaps. So after those consultations, the commission would go back to deliberations in plenary and then come up with the, I would say, suggestions or propositions for legislation. Now, those propositions for legislation are taken back to the key stakeholders and the public through another consultation, which we now call a validation workshop or conference. Normally, this is done at the national level, but the key stakeholders and some members of the public, as well as the media, are invited so that those matters are well publicized. And then from there, the commission would deliberate on the feedback from the consultative work, from the validation workshop, affirm its positions, and even come up with the proposed legislation, or rather a proposed draft bill. This is provided for under the Law Commission Act, that whenever the commission is presenting its recommendations, it can include a proposed draft bill. So once it has reached that far, then the commission calls for a press briefing where it will now highlight its key findings and recommendations for noting by the general public. And after that, the report is finalized and submitted to the Minister of Justice. It is the Minister of Justice who then takes over the process, including presentation of the proposed legislation, all the other processes that would lead now to the enactment of new legislation following the recommendations of the Law Commission. I would say within that process, regarding the review of the Refugees Act, quite a lot has been done by the Commission already. Of course, the Commission started its work in earnest in 2024. I think that was around late January or early February, when it started with preliminary consultations, including a visit to Dzaleka refugees camp and other districts around the Malawi, in all the three regions, to the north, to the south, and even at the central region. And the commission has also been meeting to deliberate in plenary. It has also embarked on one-on-one consultations with the key stakeholders. After those consultations with key stakeholders, the commission will now be moving to a national consultative conference, which would be like also announcing its tentative findings to the general public for their views as well. In brief, that's how the law reform process works. And that's where we are as regards the review of the Refugees Act. Since we are on those consultations, all things being equal, we expect the process to be finalized by the end of the year 2025. Thank you.
Thank you so much, Mr. Kandulu. That was elaborate. I wanted to ask Shakira what changes you'd anticipate from the revised act, but I remember you already said, you touched on that already. But maybe what would you say about it? Is it too early to predict changes in the Refugee Act, or what are your thoughts on that, Shakira?
I would say yes and no, but mostly I don't think it's too early to predict the changes that we'll have in the revised act. Because I mean, when as Robert has been explaining, a revision of an act comes about if there's a problem that the current law does not address. Now, looking at the current Refugee Act, what are the problems that it is not addressing? That is the starting point for us to be able to predict what changes are there in the coming act, if I may call it that. Now, one of the changes that I can predict would be clear procedures on asylum. As Victor mentioned in his presentation, that we don't have clear procedures in the current act, which means it takes longer for someone's application for asylum to be processed. It might take as long as years for someone to just have their application to go on a refugee committee, refugee board, for them to just assess, are you eligible to become a refugee in Malawi, to be accepted as a refugee in Malawi? So during that period where a person is still waiting for a response, then the person stays without knowing their status, whether they've been accepted or not. And I think this has been a very big problem, both on the government and UNHCR. So this should be one of the amendments that we should expect in the amendments. Apart from that, I would also predict that we would have a lot of alignment with international standards. Victor had mentioned something about the current Refugee Act provides, I think it's under Section 10 or something, it provides for, it prohibits expulsion of refugees. Now, but when you look at the same section, there's also a provision that allows the expulsion of refugees who are deemed to be a threat to national security without necessarily providing the adherence to principles of natural justice. So, and this is one of the reasons why we've had problems in the courts, where we have people being deported without being given a chance to be heard, because there isn't anything that provides specifically for the adherence of principles of natural justice. We know that any act that we have in Malawi also has to conform to the constitution. But I think it will also be important to have the provisions that are that align with both international standards and the principles of natural justice in the coming act. So I assume that we'll have some tweaks with regards to that provision. Apart from that, I also predict that would have something to do with, I'd spoken about durable solutions, specifically about integrating refugees with the local community, specifically with regards to access to education, tertiary education that is, and employment. Right now, we have a lot of refugees at Dzaleka camp. Now, what that means is that there's a lot of pressure with the resources that we have, not only the infrastructure, but also the financial aspect. Now, it is in the government interest to have a lot of refugees who are self-sufficient. So they've been also looking at ways how they can get refugees to also be integrated in the local community with regards to employment, looking at the current status quo, which requires for a refugee to work in Malawi, you're supposed to obtain a work permit. Now, a work permit costs you about $100 to process in Malawi. A refugee gets 15,000 a month. Now that just looking at those numbers, it will be impossible for a refugee to get a work permit. Now, my assumption or prediction would be that the review would reflect that we would have some sort of regulations to show how refugees can attain permits, or if refugees are to have special permits, perhaps those that are skilled, and see how they can be incorporated or integrated in the local communities. So these are some of the amendments that I predict ought to be there. Otherwise, then this whole thing will just be an exercise, because these are the main problems that we face. Access to justice, all of these, if we have clear stipulations, clear provisions in the Act that provides for how does one become, what is the asylum procedure, and then clearly stipulating and saying, no, you cannot just deport, or you cannot just expel a refugee, even if you think this person is, or you regard the person as a threat to national security. You have to conform to international standards. I mean, there's a provision even under the 1951 Convention that provides for that. Say, if you deem a person to be a threat to national security, have the person come, hear them out. Why? Because you have to comply with the principles of natural justice. So my assumption is these are things that are going to be reflected in the new Act, considering this was enacted in 1989. And as Robert has thoroughly explained, that during that time, Malawi was not ready to host refugees. We thought we were, but we weren't. It is evident with the law that we have at the moment. So yeah, just a few of the tweaks that I think are going to be reflected in the new review. Thank you.
We really appreciate. I hope we are all able to hear them. Without wasting time, Divine, I hope you can hear me. I have a question for you. What are some of the obstacles that you'd like to see removed, or rather you'd love to see them in the new Act or the proposed bill that is going to be there eventually after the whole revision process has ended? What would you like to see?
Well, thank you so much, Tema. That is such a wonderful question, and I wish it could have happened like the next day. But unfortunately, it will take a minute. But I would definitely like to see refugees be granted the freedom to movement. So giving them the right to settle anywhere in Malawi rather than being confined to Dzaleka refugee camp, because they have definitely a lot to do outside other than just being in the same place. And I also definitely envision a future where refugees have full access to Malawi's education system and are given an equal opportunities to grow, excel, and reach their academic or full potential. And I am a strong believer in the right to work. So not human being can live with dignity while depending on solely on handouts. Because definitely refugees in the camp depend on the donations from people. So it's hard to just imagine to just sit waiting either if someone decides you're going to eat today or if you're not going to eat, because you're just depending on donations that you're going to be given. And also Shakila just said something that I quoted. She said it's in the interest of the government to have refugees who are self-sufficient. So if refugees given opportunity to get education and also be able to work, and that would definitely, and not just benefiting them, it's also benefiting the country or the government in general. And also, this is not definitely how God intended his people to live. We are meant to work, contribute to society, and live meaningful lives. So yeah, I would say that. Thank you.
Mr. Mhango, I hope you can hear me. I have another question for you. With the explanation of the whole process that Mr. Gandulu just explained to us, do you think it would be right at this point in time for us to actually promise people or assure them that we're going to have a new Refugee Act in place soon? Or if you don't see that we can actually promise them, what then do we do in order to actually give people hope that things are on the way? Hope is coming for them. What can we do? What should we say to them?
Yeah, I think from the experience, I've been in this situation before. We are advocating for the enactment of the new Prison Act. The current Prison Act was enacted in 1956 by our colonial fathers. There was an attempt to have a Prison Act in the year 2000. It was refused by the members of parliament. They were saying that it cannot match the then current economical status of Malawi. We had another attempt. Finally, we have the Prison Act. So I cannot promise, but what I know is that I think it's very difficult for the Law Commission also to push for this because they also rely on funding from the government, and it depends on the political will of the government. But as a human rights organizations, we keep on talking. We keep on lobbying the government, and we will not stop. We will not relent. We will keep on pushing for this to happen, regardless of the government that we have. Because I've seen in the question, and as someone was asking that, what if the government changes? I can assure you whether the government change or not, but I think the government remains the same. It's only the party that changes. So we have been pushing for Prison Act. This time is going to Parliament. But the problem is, after pushing and pushing, even the Prison Act that is going to Parliament today is more or less like the 1989 Refugees Act. There's no improvement from the current. If you are reading the old act and the current bill, it's like we are reading the same document. So we just need to lobby members of parliament, and as we are a lobbyist organization, so we'll keep on lobbying for an act, and so not just an act, but it should be a human rights friendly act. We'll try to find the members of parliament who can assist us. So that will be our raw tema. So at the moment, I cannot promise because we don't even have the bill. We don't even have the report from the Law Commission. So it's a process. After that, we need to have a bill. After we need to have a report, and then we need to have a bill, and that's when the lobbying starts. But for sure, as far as we are living, be assured that I think you have a friend in Clare and other CSOs who keep on fighting for your rights, and we'll make sure that we reach that the dead end. Thanks.
I think that was somehow assuring or less assuring, but at least we know that you have the backs of refugees and that in your mind, Claire is willing to work with them. We have already passed our time and we only have another extra 10 minutes. And just to finish off, we have another set of questions and then we will talk about, we will give the panelists a chance to answer some of the questions in the comment box. And we are only asking our panelists to be brief with the next set of questions. Make sure that your answer is brief and just loaded enough so that people are able to know what you are talking about. I'll start one of the questions with Mr. Gandulu. When you were explaining the revision process, you talked about some of the challenges that you face. Would you kindly or briefly just explain to us what some of those challenges are and how stakeholders can help or come in to help the Law Commission?
Thank you very much. I think the biggest challenge so far that we have noted, which tends to significantly derail the law reform process, resource constraints, money, financial resources. For instance, holding consultations, like the regional consultative conferences, would take not less than 40 million Malawi kwacha to hold a regional consultative conference, let's say in Nzuzu. Now, if you have to go across the country, Nzuzu, and then you go to Blantyre and Lilongwe, and in some cases, Mangoji, as for the eastern region, then you're already talking about 160 million kwacha plus. That is quite a huge amount of money. And that is the more reason that for the review of the Refugees Act, the Commission has settled for a national consultative conference, which means to draw people from all over the country. And now, even with the national consultative conference, these people have to be accommodated in hotels, or rather in reasonable accommodation of good standard. They have to be reimbursed transport. They have to be fed. So a very modest figure for a national consultative conference would be maybe around 60 million Malawi kwacha, which I dare say at the present the Law Commission does not have. But we have, I would say, partners of goodwill who have been sponsoring the process, and we are hopeful that at the material time, they would come in. That said, the Law Commission Act allows the Law Commission to receive assistance from any other institution, so long as that assistance does not compromise the independence of the Commission in its findings and recommendations. In other words, assistance with no strings attached. So regardless of the fact that government, through the Department of Refugees and the United Nations High Commissioner for Refugees, are currently sponsoring the process, it remains open to others to still come in. They can just pick like an aspect of the process. For instance, the National Consultative Conference we are talking about, they could come in to say, okay, for that one, maybe we'll assist with conference facilities, the accommodation, so that we can bring in as many people as possible. At the moment, the best we can do is maybe get 10 people from the northern region, 10 people from the southern region, and the majority from the central region. It might not be very representative. We can have a situation where we can bring in 30 people from the north, 30 people from the south, and as many as we can at the center, a conference of maybe 200 delegates. I'm sure we are going to have very meaningful dialogue. So if there are those who can come in to assist, maybe just this aspect of the National Consultative Conference, that would be very welcome. That is apart from the other things we can discuss for them to assist in due course. Thank you.
Divine, I'm hoping that you have listened to what Mr. Kandulu has said. Briefly, if you were able to raise funds in order to help the Law Commission, what would your message be to the donor community about helping the due process of revising the act that will at least help the people or the refugees in Malawi?
My message would just be as simple and straight, because I would tell the donor that changing the Refugee Act is urgent due to the harmful impact that the current law has on thousands of people. So supporting the Malawi Law Commission in revising this act means helping refugees gain access to education, freedom of movement, and the right to work. So this is a noble effort that deserves the backing of all. It reflects a Malawi that upholds human dignity and stands for justice and equality. So that message would just be like, okay, that's all we got. Thank you.
Thank you, Divine. Thank you for the straightforward message that you've given to the donor community. And my question to Victor now, you've heard there's a lot of people just like Divine wanting to continue with the education in the public universities. There are many like her wanting to engage in paid employment. And there are many like her wanting to be able to move freely in the country. And with what Divine has said, and what the local, Mr. Kandu has said. With the two combined, what do you think the civil society can do, or maybe how do you think you can assist in the speeding up the revision of the Refugee Act?
Being an organization that lobbies for policy change in Malawi, I think our role will be to lobby the government to make sure that they should provide money, funding for the Royal Commission, so that the Royal Commission should proceed producing a report and actually having the bill in place. I will tell the Minister of Finance mostly in his face that the Honorable Minister, the 1989 Act is denting the the good image of the Malawi government. We are known as the people who are warm, but the current there have been some issues recently to do with refugees, arresting them and taking them to prisons with their babies, which is un-Malawian. So I'll tell them that I think if we keep on maintaining the current one, then it means that the image of the country is going to be dented. So I'll make sure that the government should give the resources to the Law Commission so that they should do their work.
We hope, and we know that we've got a listening government, and we know that once you reach out to them with these propositions, they'll be able to do something about it. And maybe a last question to Shakira. There are many like you in human rights law. How do you think you can support the Law Commission in the revision process? Your organization or even others in your state, like people working in human rights as lawyers, how do you think you can support the Malawi Law Commission in the revision process?
I mean, as lawyers, there's a lot that we can do to assist the Law Commission during the revision process. I mean, to just mention a few, even during the consultation, for a review of an act, there's a lot of research, a lot of drafting. So as lawyers, we can assist in that, rendering our expertise in drafting, in research. There's a lot of analysis that has to be done, comparative laws. So that is something that I know that I and lawyers that are in the space, in the human rights space, would be willing to assist in that during the consultation. And even after that, even after the enactment of the bill into a law, we can assist in public awareness, in trainings and workshops to have people understand what is the impact of the revised law, what do the changes mean, this and that, even sensitizing the refugees themselves, holding advocacy, being part of advocacy campaigns, and many more. I mean, we also do a little bit of lobbying, but I'm sure in this case, I know that Victor, this is Victor's space. He has been doing this for quite a while. And yeah, that's pretty much it. We can help in so many ways, but especially in like drafting and public awareness campaigns and trainings. Thank you.
Thank you, Shakira. Yeah, it's good to know that we've got people like you in the corner waiting to help. And we know that there are many others as well that are willing to assist. So hopefully, where anyone is willing to do something to speed up the process, we would encourage them to reach out to the Malawi Commission, to Malawi Law Commission, and find out how best they can assist them. As we're winding up, we have some few questions in the chat section. There's one question by Ismail. That's a Somali community leader in Dzaleka. He's asking, given the current discussions on reviewing the Malawi Refugee Act, how realistic is it to expect a new law that effectively addresses refugees' issues in line with international standards? So I think he's trying to find out how realistic are they supposed to be hopeful of the change? Maybe that's something our panelists will be able to assure them. Another question is from Alain. He's asking, I think Alain's question, and there's another one. Okay, there are two questions, similar questions to the Law Commission, asking how Malawi's current Refugee Act aligns with the 1951 UN Refugee Convention and its 1967 protocol.
I wouldn't want to make any promises on that one, but let me just restate to say the whole process, or rather the whole essence of law review, is to make sure that we have a law that is modernized. And by modernized, we mean a law that conforms to the Constitution of the Republic of Malawi of 1994, which postdates the 1989 Refugees Act. And again, that the law that is so developed aligns to international obligations that Malawi has under various instruments. And maybe it also meets certain international accepted standards. But because in lawmaking, there are always, what I may say, varied interests, that's why we need to go through a consultative process on each and every issue. Still, at the end of the day, the whole objective is to come up with a law that has been reformed. That's why we talk of law reform or law review. I'm not promising anything, but that's how the process is designed to achieve certain changes. As to the second question, I think I've provided a bit of an answer typed where I'm saying the act is in many respects aligned to the convention, maybe not as comprehensively as one might desire. But we should also be mindful that there are 9 reservations that Malawi made to certain articles to the convention. However, even for those articles where Malawi entered reservations, we have seen in certain cases Malawi moving beyond the reservations to address certain exceptional cases. So I would say it's not all cast in stone. There is some fluidity. And if we look at, for instance, Section 10 of the Refugees Act, it enshrines the principle of non-reforma, which I'm sure is the key pillar of the 1951 United Nations Convention and its 1967 protocol. Thank you.
Thank you, Mr. Kandulu. And there was another question to Victor. Based on your explanation, I would like to understand the impact on Refugee Act revision. My question is, how will the revised Refugee Act improve the living conditions and legal protections for refugees in Malawi? So I've seen that Victor has already responded to that question, that there's currently no bill, but as human rights organizations and civil society organizations, they will continue to lobby for a human rights friendly act. So hopefully once the act is revised, it will be human rights friendly. That's how Victor is putting it.
Those questions were really insightful. For those who still have questions, you can reach us on our Facebook page. If we can, we're going to be able to provide you with answers. And where we can't, we're going to refer you to the right people to answer your questions. Just to close up, we wanted our panelists to say something, a takeaway statement that maybe we might all remember them by.
This has been quite an insightful discussion for all of us, including myself. And I hope that we've all taken away something. We've learned 1 or 2 things of the current law and our hopes and anticipation with the revision of the Refugee Act. Just to wind up, as legal practitioners, we know that the strength of any law is in its ability to protect the vulnerable and uphold justice. So this review isn't to be taken as just an exercise. It is an opportunity for us to ensure that Malawi's refugee framework truly reflects our commitment to human rights and dignity. Thank you.
Mr. Mhango, anything you'd like to share with us as we are closing?
As human rights organizations, we always categorize refugees as vulnerable groups. They are vulnerable groups because these are people who have left their homes, they come to a foreign nation to deliver justice, and if at all their rights have been infringed, they want to access justice through our courts. So it's unfortunate that as we are talking now, with the current status, our friends from different countries, they have been denied access to justice. So we need to energize the criminal justice system through. We need to energize the criminal justice system. At the moment, I can describe it as it is sleeping because it's not responsive. It does not respond to the concerns and the issues of refugees. So we'll try to energize the system so that it should be responsive. Thanks.
So, yeah, I would just simply say one thing, just a few words from the whole discussion. And this would basically just be a reminder to any Malawian or any official representative who's here with us, and also as well as a reminder to fellow refugees on how resilient, strong, and hardworking they are, so that they should always remember that in everything they're doing. So I would simply say that refugees are often seen as vulnerable people, just like Mohango just said. But refugees are often seen as vulnerable, but we are more than our struggles. We are human beings with talent and dreams, ready to contribute if given the chance.
I think I've obtained a number of valuable insights from this interaction, some of which I've recorded. So I will not repeat those, but maybe just to extend this invitation to say whenever a law reform process has been initiated, it remains open to interested parties or stakeholders to send in submissions or views as to what areas they would like the commission to consider. And those will always be taken on board. Of course, at the end of the day, the commission might not reach the conclusion that the person submitting was hoping for, but they would still have addressed the issue. In some cases, if it's not provided for in legislation, maybe it finds its way in the policy recommendations of the commission. So let me use this platform to invite those further submissions from all interested parties here, addressed to the law commissioner, but of course for the attention of the program officer for the review of the Refugees Act. As to the address of the Law Commission, Private Park 373, Lilongwe 3. In terms of the email address, I think for now, you can use the my email address, the one I have shared with you, while waiting for me to the official email address of the Law Commission, so that the submissions can go direct to the office of the Law Commissioner. Thank you.
Thank you so much, Mr. Kanduru. This was indeed a timely discussion. It needed to be had. I think, like many other people, I've really been educated. I thought I knew things, but turns out I know nothing. I have to go back to the drawing board. Just to encourage everyone that was online, please go and look at our Refugees Act. You will see the many gaps that have been talked about in this conversation. We will also encourage you to go and rewatch this Zoom meeting that we're going to post on our Facebook and other pages, Inua Advocacy. There you'll be able to get the things that you missed or the things that were not so clear, and maybe you can also find questions from there that you'd like to ask us. Like the commissioner, Mr. Kandura has already opened up. He's willing to answer any of our questions. So we'll be able to try and get answers from him and get back to you. With this, I would like to close this meeting. I would really, really so much love to thank all our participants or everyone that attended this Zoom meeting today. We know that with the current economic status in Malawi, buying a bundle isn't such an easy thing, but you took your time and were able to attend to this meeting. We are really grateful. We hope that you join us in our next Zoom meeting. For our friends in Zalega, we hope that you continue seeing that we are still advocating for your rights, and we are continuing to support you, and that we are going to continue doing that through information sharing and other things that we're going to be able to do as Inua Advocacy. We are also going to just thank our panelists. Divine, thank you so much for sparing your time. You had school and you're also missing sleep, but you really took your time to join us. I'm really happy to have met you, though we have met online, but I feel like we are now friends. Thank you so much. Thank you so much, Mr. Victor Mhango, for being here with us. With your busy schedule, you took your time to come and just support Inua. You are always supportive of us, and we're truly, truly grateful. May God bless you and the works of your hands. We hope that the partnership we have established will continue as we go. Thank you so much to Mr. Robert Kandulu. You are a government employee, and I know that sometimes things like these are not so easy. You took your time, you were willing to help us. I am really grateful. I hope that when we come to knock on your door again, you will avail yourself. Thank you so much. Thank you so much to Shakira Panda Odila. You are always supportive of Inua. I'm really, truly grateful that you took your time, left your managerial laws to just come and inform refugees and all of us here about the laws in Malawi that affect refugees and asylum seekers. And yeah, I am truly, truly grateful to all of you. Just to inform you, we're going to have another Zoom meeting in April. Hopefully it shall also land on the 20th. We shall be publishing what we shall be discussing in that Zoom meeting soon. I hope you are following all our pages. We are on Twitter, Instagram, TikTok. We also have LinkedIn and Facebook. Please follow us and continue supporting us. Thank you so much. You may